Imagine being in jail and still finding a way to break the law right under the judge's nose. Today, we're diving into a courtroom showdown where zero tolerance meets reckless defiance. Who's telling the truth? Who's bending the rules? And just how far can one defendant go before the law catches up? Buckle up, this case is about to get explosive.
But in any event, we have a bond issue that was brought to my attention, so we needed to address that. And so we are on the record in the matter of the state of Michigan versus Amir Boykin, 231785. And appearance for the people, please.
Good afternoon, Your Honor. Omar Shah on behalf of the people, PH 6332.
And good afternoon, Your Honor. Luther Glenn, P38683, appearing on behalf of Mr. Amir Boykin, who appears via Zoom from the Wayne County Jail.
Amir Boykin.
Thank you. I'm sorry.
Amir Boykin.
All right, thank you. Hold on, are you with an F today or no?
Huh? I couldn't hear you.
What did you indicate your last name is?
Boykin.
With an S or without an S?
Without an S. Boykin.
Okay, it sounded like you said with an S, but okay. Today's the date scheduled for for the exam, and it was set for 1:30 p.m. Mr. Boykin had his sentencing down at Third Circuit Court, Frank Murphy Hall of Justice, and then he was set to be here at 1:30. The communication with the jail was that he was on his way here, but in fact he was on his way back to Wayne County Jail. And then it was brought to this court's attention that there needed to be a bond issue addressed, as well as the fact that there had been a witness detainer that this court had signed that was submitted to it by the prosecuting attorney's office. Okay, Mr. Shajra.
Thank you, Judge. Judge, I think it's important for us to go back to the prior proceeding to which we did issue a witness detainer on behalf of the complaining witness, Judge. Prior to this case, Judge, as the court is aware, we had an FFDD case with the same defendant, same complaining witness, Judge. There was a prior bond violation. There was a no contact, no go to order. He violated, picks up this case, Judge, of unlawful imprisonment and resisting obstructing a police officer. Now, Judge, it came to our surprise that the complaining witness just stopped communicating with us. She indicated that she didn't want to participate in the process. So I did reach out to the OIC on the matter. I indicated and asked him whether or not he could pull the jail calls and information as it pertains to Mr. Boykin. He indicated to me, and I do have the documentation to show that Mr. Boykin has on multiple occasions.
Start from midnight and end at 2:47. Buckle up, guys. Today we are going straight into a courtroom where tension sparks from the very first words. The judge opens with the charges, serious felonies tied to intimidation and assault, while the defendant sits behind bars on a bond violation. What should be routine quickly gets messy as even the spelling of his name causes confusion. This is no ordinary hearing. It's a setup for fireworks.
Reached out to the complaining witness on the matter, Judge, sending multiple messages, including text messages, Judge, as well as phone calls. We don't know the context of the phone calls yet, Judge, because we haven't been able to get those from the jail itself. But we do have the text messages, Judge, between the defendant and the complaining witness as it pertains to participation in this prosecution.
How was the defendant able to text message from jail?
Judge, it's my understanding that the Wayne County Jail does provide tablets to which he was able to communicate to me.
My daughter was sick. That's why I was talking to her. My family told me that my daughter had.
Sir, I'm sure your attorney is going to advise you that you may not want to indicate anything right now because no contact is no contact. Zero.
All right.
I'll take a look at those, please.
Judge, may I approach you?
Yes, you may.
Go.
All right, and so, Mr. Glenn, I will also note, I don't know if you've been afforded.
Which I did have copies for Mr. Glenn, however, he's not here.
Okay, and so What is the name of the complaining witness, counsel?
Oh,
Is it Daisha Griffin?
That is correct.
Okay. So the court is looking at, let's see here. Mr. Boykin has been in custody since September 27th. Well, no. Has Mr. Boykin been in custody prior to September 27th? He must have been, because he was in custody at the Wayne County Jail. Oh, he was in custody on another matter.
That is correct, Judge. He was on bond for the incident with the same complaining witness prior to in this court where it was bound over. He then absconded from the tether on this matter, goes to the complaining witness's home and makes contact with her there.
Oh, okay, that's correct. Okay, so let's go all the way back to even July 11th. Well, let's see. We have, well, actually, I'll go from September 27th on this matter specifically. What was that, sir?
nothing, man. How you say that?
After September 2nd, there isn't anything in here until September 27th. I'm sorry, September 29th, which was 2 days after Mr. Boykin was arraigned in this court, which the court was very clear, and we're going to read the bond conditions. In fact, sir, I'm going to have you please raise your right hand. You solemnly swear affirm the testimony you're about to give this, sir, please raise your right hand.
Oh,
Solemnly swear affirm the testimony you're about to give this matter be the truth, the whole truth, and nothing but the truth.
yes, ma'am.
Okay, so the court will note that the bond was $100,000 cash bond.
All right, guys, this is where things heat up. The prosecutor lays it all out, claims that the defendant, despite clear orders, was still contacting the protected witness. The judge, clearly skeptical, asks the question on everyone's mind. How does someone in jail manage to text at all? The implication is clear. Rules were broken, and now the court wants answers. You can feel the storm brewing.
No contact with the complaining witness, phone contact, text message, email, social media, third party, anything of the like. You're not to enter the premises at her home or employment. You're not to possess, consume any alcohol or drugs unless prescribed. Not to possess or have access to firearms and or any weapons. And you are to obtain a GPS tether house arrest in the event you posted bond. So, no contact is no contact. This communication from the jail is September 29th, 2023 at 15:04 hours. Sent by Mr. Boykin to Ms. Griffin. When you send the pics, 1321. Can you send new pics of y'all, please? Then at 15:04 on the same date of September 29th, when you send the pics, make sure it's pics of you too, Daisha. September 29th at 15:08. I really miss y'all a lot, even though the judge don't want me talking to y'all. I just know she's not gonna be happy or work with me anymore. But most people don't know that I love y'all, man. I just wanna get out and do the right, nothing, this, not, nowhere. Nobody wanna be you. No, I just get up every day and ask God to let me make it home to you guys. You know, I miss y'all a lot. Then right after that, I meant to say thing. September 29th at 15:47. Said by Mr. Boykin, whenever you get time, can you pick up the phone? I know you got something going in, and I'm not trying to come in the way of that. So when you have the time, can you pick up the video visit thing? I'm going to set a lot up. Just pick up the one. Work best for you. I really have something I want to talk to you about. Same day, 1940 hours. I love you guys. I talked to y'all Sunday. Hope you enjoy the time with your grandma. Love y'all. Kiss my mama for me. Can't wait till them pictures come through. Good night. So on September 29th, 1, 2, 3, 4, 5, 6 communications by Mr. Boykin to Ms. Griffin. September 30th, I got the pictures. You so Lowell now and Mama starting to look like the both of us. I love you guys. Enjoy the day. Make sure to send more pictures of you guys. Love y'all. Enjoy y'all day. That was at 12:43:22, 12:45:28. Y'all look cute. All by Mr. Boykin.
Here's where the excuses begin. The defendant jumps in, saying he only reached out because his child was sick. But the judge isn't having it. He cuts through the story with one harsh truth. No contact means no contact. 0. This moment shows the clash. Parental concern versus strict court orders. The defendant pushes, the judge pushes back harder. And the tension? It's only rising.
Ms. Griffin responds on September 30th at 12:54. LOL, told you she starting to look like me now. She still look like you too, but you can finally see how we resemble each other when we're next to each other in pics videos. Love you too. Enjoy your day as well. Then September 30th, 13:14:28 by Mr. Boykin. She's so big now. I can't believe it. I love my mama so much. I can't wait to see her. She looked like you when you was a kid one day. She looked like you the next day. She looked like me. I'm so happy that I had a kid with you. I love you guys. I text you later on. Don't forget my pictures. Daisha, I know you're about to have a long day, so I'm gonna let y'all get going. Stay safe. Probably supposed to be safe. But don't forget you the one at all times. I love y'all. Kiss my mama for me and make sure you give my baby some food if she won't. If she wants some.
Ma'am, I was not saying
Let's see.
nothing for you getting it.
I'm sorry?
Ma'am, at the end of the day, like, what do you expect? I have a kid with her. I don't know why this prosecutor trying to make it a big deal. What you want me to not to be in my kid's life? Like, I don't know where y'all going. I did not nail her hostage. I did not do no unlawful imprisonment. When they came, it's in 2 statements of her saying I never forced her. So I don't know where y'all trying to get. I have a kid with her. What you want me to stop communicating with her and my kid? Like, just make it make sense.
Yeah.
You can do what you want.
Sir,
I don't care.
Sir, this court ordered you not to have any contact. That's 0 contact. So
Yes,
yes,
but my
I
other
expect
judge
you.
said that I can
Excuse
co-parent.
me.
My other judge said I can
Stop
co-parent.
talking. Stop talking. Right now, you're not co-parenting with her. You are in the Wayne County Jail. You are not to have any contact with her whatsoever. I was very clear about that.
Let's translate what just happened. The judge reminded everyone $100,000 cash bond and absolute no contact, no calls, no texts, no DMs, no third parties, no exceptions. Then she reads a series of messages dated September 29-30 and into October 3-4, including the defendant explicitly acknowledging the judge doesn't want him communicating and continuing anyway. That's the legal landmine. Even if the content sounds loving or about co-parenting, intent doesn't erase the order. A no-contact condition is binary. You either comply or you don't. The prosecution frames this as a pattern that chills witness participation. The defense says this is overreach and not contempt within this proceeding. Question for you: should co-parenting carve-outs ever override a no-contact bond? Or is the court right to enforce zero tolerance? Sound off.
Very clear about that. Yet you know that I'm clear about that because you make mention of that in your message to Ms. Griffin on September 29th of 2023 at 15:08:38.
Okay, but my other judge said that I can co-parent with her as long as I'm not threatening her. And that court overruled you. It's a 3rd district court, not a 27th district court. So if you want to just buy my stuff over, just do it. Just do it. I don't care anymore. Do whatever you gonna do, bro.
Let me be very, very clear with you.
Because my judge just told me today, I got the paperwork, I can co-parent. It's in black and white.
Sir,
That's what
let
she told
me just tell you
me.
this. Stop talking.
If she says she don't want to participate in the stuff, you're supposed to drop the case.
If your judge, I just muted you because you're not listening to this court and you're not giving me an opportunity to state what I need to state.
Now it gets uncomfortable. The judge starts reading the actual jail messages out loud, proof that the defendant not only knew the rules but ignored them. The texts aren't about the child at all, but about jealousy, personal drama, and defiance. The defendant argues back, but the judge shuts him down cold. He's not co-parenting, he's sitting in jail. The gap between his words and reality becomes undeniable.
If the judge on the other case that you're bound over on made the comment about co-parenting, I don't know, I wasn't there. That judge does not overrule this court's authority regarding bond on case number 231785. I am making that very clear to you, sir. Unless there's an appeal file that appeals this court's bond orders, that court does not overrule this court on this bond condition on this case. Again, you're muted, sir. You're muted. Stop talking, please. I'm sorry, and yes, Mr. Shadra?
Judge, and I think it's important to elaborate on the fact that as it pertains to the complaining witness's presence in court today, officers were looking for Ms. Griffin for almost a week now. They sat in front of her house, they went to her place of employment, they spoke to her relatives. She indicated that she didn't want to participate in the process. Finally, we were able to get her here today, Judge. She said that, in fact, he was the reason why she didn't want to come to court. And Judge, when we looked at the defendant's history, he shows a reckless disregard for this court's orders. It's very important to note, Judge, that these bond conditions are for these complaining witnesses to feel safe. That's why we implement them, and we need them to get to court. And Judge, this is ridiculous. This has happened over a multiple amount of times, and we ask that the defendant in this case be given jail time as it pertains to the bond violation, Judge.
Mr. Glenn, your response.
Well, if you're asking for jail time, that's criminal contempt. That's not an issue with the bond. The bond, he's been in jail and he can't make the bond. So if there's something that's going on with holding him in contempt for violating order, that's a separate proceeding.
Like, I don't care, bro. Like, he's lying. If I'm the reason she not coming to court, I actually told her to come to court and tell the truth. It says in the paperwork she was never held hostage, bro. He's making up a lot. Go read the paperwork for yourself. I can pull the statement out and read it out loud to you. She never said I held her hostage. It's her house. She got the right to say, go get a search warrant. So how I'm being charged with unlawful imprisonment? I'm getting overcharged. That's why when they get to 3rd District Court, they gonna drop it and just hit me with resisting arrest. Because there's nowhere to say that I forced her against her will. I'm being overcharged. And he's lying. I never told her not to come to court. If you go listen to the phone calls, I told her to come to court and tell the truth. What is you talking about, man? The man lying, bro. But go ahead and do what y'all gonna do, because I don't care, bro. I'm gonna get out eventually. All y'all doing is overcharging me, bro. Overcharging me. This shit right here in black and white, bro. We can read this shit together. When the detective talked to her, she said,
listen, you are in court. You are in court. Stop your cursing. And the court's going to note as well. And first of all, there is a very
you can't get nobody with imprisonment. It says right here. It says
talking.
Detective contacted Griffin on 7 to ask her to restate this incident. Again, Griffin stated that when police knocked on the door, Boykins be.
Mr. Griffin, you need to stop talking, please. Stop talking just for a few moments. The court will note that some of these messages are quite descriptive in detail regarding what Mr. Boykin would do when he gets out. Specifically, October 3rd, 2023 at 21.
This part is pure fireworks. The defendant insists another judge gave him permission to co-parent. The courtroom erupts as he keeps talking over the bench, claiming he has approval. But this judge isn't playing games. He makes it clear no one overrules this court. And when the defendant won't stop, the judge literally mutes him. It's a stunning moment of authority clashing with desperation.
28:33. You 27 minutes left. You must be with dude or on the phone with him. It's all good. I talk to you when you get off work. Late that same day, 21:36:27. You're not gonna make the call. It's all good though. I be you real soon. My time comes. Just wait on it. Kiss my kid for me. You can't take 3 minutes out of your day to make a visit. You sad like man, but hey, my life in your hands. So let me not play with you. Kiss my kid for me and enjoy the time on the phone with the nigga that don't want to do shit, but use you for sex one day, you would get it before it's too late. Then on 10-4, 20-27-45. Yeah, you playing mind games and kid-ass games. You never called. You're a liar, bro. If you laying up with a nigga, just say that. And I stop calling you. Better yet, you got it, bro. That's my last time calling you. You a liar anyways. Then, it's showing the last one was October 4th. Were there not any further communications after October 4th?
Judge, we were made aware that there was also phone calls that pertains to the defendant and the complaining witness. We were just not able to pull them at the time, given that the software was not at the jail. And Judge, the OIC can make a representation to those phone calls as well.
All right, and Detective McDonald?
Yes, Detective McDonald, MC, Orlando for the police department. I contacted I believe it was Captain Solberg. This person is Michael Solberg in regards to these records. I was directed over to him by the Wayne County jail staff. I sent him an email regarding Mr. Boykins' information and requested any meetings, text meetings, anything like that. He was able to send over what appeared to be some audio files. It just appeared that we need to use a different form to actually listen to them. So I do have some audio files. I'm just figuring out how to actually play them.
Okay, well, I'm not really sure how there aren't restrictions put on communication devices when there are protective orders in place. So what this court is going to do is, as a condition, an amended bond condition, the court is going to restrict Mr. Boykins' use of tablets and phone. That way we know that he will not be violating this court's order and he will not be contacting Ms. Griffin, nor having anybody else contact Ms. Griffin. Let me be very clear, Mr. Boykins, you're not to contact her by mail either.
Okay, so wait, I don't understand. Why you trying to give me some charges when she said she don't want to participate in the thing? I'm suing y'all. It's all good. Because if I'm still being like, y'all put out a warrant for her. She told y'all she don't want to pursue the charges. For one, what I'm trying to get you to understand, if you go read the report, she never said unlawful imprisonment. When she talked to this detective, when he asked her, he had her to restate the issue. She said she never said she was held hostage or anything. Why am I being charged for unlawful imprisonment? If anything, it sounds like a resisting arrest. So you know what you can do? You can just bond it over, and when I get to the 3rd District Court, they're gonna drop you to a resisting arrest. Because in here, I never held her against her will, and she said that. That's why I'm saying you listening to them when you should be reading the paperwork. You should be, because how can I be charged with something and she was never held against her will? And they say this in black and white. Two different statements. Her statement, and when he talked to her on 7-1, it said that I was never forced to do anything. He overcharged me, and I'm letting him know when I get up, I'm facing a lawsuit.
Mr. Boykins,
I'm facing a lawsuit. So go ahead, bond it over, and hold me in contempt of court. Because she's not even here. How can you give me a charge when she's not even at court to speak up on her rights? I got the right to cross-examine the witness.
Mr. Boykins, much to your surprise, Ms. Griffin is here and ready to testify.
All right, so go ahead and get it.
Excuse me. The only reason it's not going right now is because you were not delivered in person. So, Ms. Griffin is here and ready to testify today.
Testify. Have her testify. Have her testify, because I want to hear it.
Sir, you're not here in person, and I'm not conducting this preliminary exam over Zoom.
She gonna say that I never healed her against her will. So what's the difference from in person and Zoom? What's the difference? If I'm giving you the okay, we can do it to Zoom. Why can't we do it in Zoom? What's the difference? Why I gotta be in person? We already here. Everybody already here. So just stop wasting everybody's time.
Mr. Glenn?
The prosecutor steps back in, driving the point home. They say the defendant is showing reckless disregard for the court, and the only answer left is jail. That's when the defendant loses it completely, accusing the system of overcharging him, yelling, even cursing in frustration. The judge snaps, warning him to stop the language. You can hear the walls closing in and his control slipping away.
Your Honor, Mr. Boykin has indicated that he's willing to waive these proceedings and proceed on to circuit court. I would ask the court to.
No. I don't want to waive nothing because I want to hear the stories. I want you to question her statement and his statements. I'm not waiving nothing. I'm not waiving nothing because I'm not about to be charged with some shit I didn't do. Hell no.
Sir, again, you're on the record in court, sir. So can you please check your language? So.
Right here. Why can't we do it right here? Yeah, stop.
Mr. Glenn?
Okay, if Mr. Boykin is okay with doing it by Zoom, we can do it by Zoom if the court pleases.
Well, I have some concerns with your client's ability to not interrupt court proceedings and not interrupt testimony because he hasn't even been able to stop talking while I've been talking.
Judge, as it pertains to the preliminary exam being via Zoom, I don't think you have the means of doing that right now. The complaining witness is present here in court today, Judge, but I think it would affect my ability to, or the defense's ability to cross-examine the witness.
I have a standby counsel. William Glenn is in the courtroom for a live exam.
Who's in the courtroom?
Oh. William Glenn, my brother. You asked me to send somebody.
That's why I was so confused because the two of you look very much alike, and I was very confused because you were here and he was there. So
yeah, we're twins. We're twins, and
that makes it even more clear. Okay, thank you.
Yeah.
All right. Counsel.
Judge, the people are ready to proceed. If the court permits that,
we will permit it.
Via Zoom, then no problem. We'll call our first witness.
Okay, let's call your first witness.
Are we doing this exam first, Judge, or Mr. Hill's exam?
We're going to do this one because we have the jail right here. I apologize, Mr. Hill. The jail said I have to do this one first.
Okay, Judge, are people called Aisha Griffin to the stand?
Good afternoon. I apologize for your wait today. Please raise your right hand. You solemnly swear from a testimony about to give us matter the truth, the whole truth, and nothing but the truth.
Yes.
Thank you. All right. I'm going to have you please have a seat. And you sound like you are a very quiet speaker. So if you can please scoot all the way up to the microphone. And if you can state and spell your first and last names for the record, please. And in fact, I'm going to mute the jail for right now.
Okay, Judge, for the record, is it Mr. Glenn Jr. that's going to be presiding on this case or his brother?
Yeah, William Glenn will be conducting the hearing because the court ordered that a counsel be live. That's why he's there.
Okay, very good. Thank you.
Is the defendant in this case also consent to this?
Well, I'm going to unmute the jail there real quick. And Mr. Boykin?
Yeah. Can you hear us, Your Honor?
Yes, I sure can. Thank you.
I'm sorry.
Boykin, are you consenting to this matter being held via Zoom with Ms. Daisha Griffin being present in person, you having counsel on Zoom and in person, and you being on Zoom in the Wayne County Jail? Are you consenting to the examination continuing in that fashion?
Yes, ma'am.
Okay, you understand that you do have the right to have an in-person exam when this matter was scheduled for an in-person exam, correct?
Yes, ma'am.
And for some unknown reasons, there was maybe some miscommunication somewhere, but the Wayne County Jail delivered you back to the Wayne County Jail instead of to the 27th District Court. And so therefore, that is why we are in two different locations right now.
Yes, I understand.
Okay, and you may, if you would like to adjust the podium, you may. Okay.
Good afternoon, ma'am. Can you please just state your name for the record?
Yes, my name is Daisha Griffin.
Thank you.
And I'm going to take you back to the date of 6/30/2023. Do you remember this date?
Yes.
And were you at the location of Pennsylvania Road, apartment 4 in the city of Riverview, County of Wayne?
Yes.
And what's at that location?
That's my apartment.
Okay, and who are you at the apartment with on that specific day?
I was with London, my daughter, and my daughter's father.
Okay, was he there for the duration of the day?
No, he was there just for like 5 minutes. I would say.
Okay, you indicate this individual here, you share a child in common with him?
Yes,
And was that your daughter that was in the residence on that day?
yes.
And do you see Mr. Amir?
And just when you think it can't get worse, it does. The judge digs deeper into the messages, pointing out they're not just violations, but full of jealousy and manipulation. It's clear the contact was personal, not parental. Then the hammer falls, new restrictions. No phone, no mail, no tablet. Communication shut off completely. The defendant's world narrows, and the courtroom tension is at its peak.
Yes.
Can you please state where he is, or where he's located in the article of clothing that he's wearing?
It's like that, maybe dark blue, dark gray. He's right down on the collar, I see.
Then let the record reflect the identification of the defendant in this case.
Okay, and Mr. Glenn?
Okay.
Okay, thank you.
And would it be accurate to state that there was a prior domestic violence issue with you and Mr. Boykins and there was a no contact order in place, correct? Okay,
I need you to be louder, okay, ma'am, please?
Correct.
Thank you.
okay, and that included no contact, correct?
Correct.
Okay, and on that day, was that no contact order still in place?
Yes, correct.
Okay, so is there come a time where Mr. Boykins ultimately made contact with you?
Yes.
How so?
He called me.
Okay, and did you pick up?
Yes.
Okay, did you know it was him?
Yes.
Okay, how did you know that it was him?
Because he calls me a lot.
Okay, was it through the normal number and normal channels that you guys communicate through?
Yes.
Okay, and what if anything did he say to you at that time?
He was asking, could you come see London?
Okay, and
I'm sorry, can you come see what?
London, the baby.
and is that your daughter?
Yes.
Okay, and what if anything did you say to him?
Well, at first I kept saying it wasn't a good idea. He didn't just ask one day. He had been asking for a couple of days. I kept saying, it wasn't a good idea. It was an ongoing case and everything.
Right, because you knew that there was a no contact order in place.
Yes.
Okay, so you refused multiple times.
Yes.
Okay, and then what if anything happened after that?
Just the same thing. He just kept re-asking, and then I finally agreed to let him come see like this.
Okay, and did he come to the residence?
Yes, sir.
The apartment building, correct?
Yes.
Okay, and did he knock on the door?
Yes.
Okay, and did you allow him inside of the residence?
Yes.
Okay, and what if anything occurred while you guys were in the residence?
We was in the residence for maybe 2 or 3 minutes, and then like shortly right after, I think he was going to go wash his clothes, and then right after that's when you guys came knocking on the door.
Okay, when you say you guys, who's you guys? Okay, and did you make contact with the police in regards to why they were there?
Not that day.
Okay, and to your understanding, or do you remember the fact that the defendant in this case, Mr. Boykins, had a tether?
Yes.
Can you describe the condition of that tether?
The tether was beat up bad.
Okay, beat up badly, what is that?
As far as it looked dysfunctional.
Okay, were there wires protruding from it, maybe?
Yeah.
Okay, and did that concern you in any way?
Yes.
Okay, so you get there, he gets there, you indicated that he wanted to wash his clothes.
Yes.
Did he say anything to you while inside the residence?
He was just happy. Like, he was real happy. He came in like real excited.
Okay, and did you tell him at any point that you wanted him to leave the residence?
No, sir.
Okay, and anytime during that, did he have communications with you as it pertains to any criminal matters
No.
that you guys were both involved?
As far as, no, like everything happened so quickly, didn't even get to like the case or anything.
Okay, and then you ultimately indicated that the police arrived, correct?
Yes.
Okay, did you make contact with law enforcement?
Once they arrived at my door, yes. Prior to that, no, I didn't call them or anything.
Okay, do you remember an officer knocking on your door?
Yes.
Okay, what if anything did he say?
He thought I had called him, like set him up, like I think that I was supposed to come.
Okay, and how did you respond to that?
I started crying and I said that like I didn't like send him there to try to set him up and send.
Finally, the judge drops the surprise. Despite everything, the witness herself is present and ready to testify. And with that, we hear her voice for the first time. She confirms the no contact order, admits he kept calling, and even let him visit. It's the cliffhanger moment. The story isn't over, it's just beginning. That's going to wrap it up for this breakdown. If you enjoyed this video, don't forget to like, subscribe, and we'll see you in the next one.